Please be seated.
Good afternoon, everybody. Madam Registrar, will you open the proceedings?
Bon après-midi.
Good afternoon, Mr. President. Good afternoon, Your Honors. Trial Chamber 3 of the International Criminal Tribunal for Rwanda, composed of Judge Van Jensen presiding, Baktia Tuzmuk Kamidov and Bedau Gustav Kam, is now sitting in open session today, 5th November 2009, for the delivery of the sentence in the matter of the prosecutor versus Michel Bagaragaza, case number ICTR-2005-86-S. Thank you very much, Mr. President.
Thank you, Madam Registrar. Are there any matters to discuss before we proceed to reading the summary of the judgment? This is not the case. I will proceed to read the summary. I will do it slowly because there's not been sufficient time to provide the interpreters with the French translation. The summary reads as follows. Today, the Chamber delivers its sentencing judgment in the case of the prosecutor versus Michel Bagaragaza. A summary of the judgment will now be read out. The written reasons for the judgment will follow shortly and will be the only authoritative statement of the Chamber's findings and reasonings in this case. Michel Bagaragaza was initially charged with conspiracy to commit genocide, and in the alternative, complicity in genocide. Another charge was added later to the indictment. On 15 August 2005, Bagaragaza voluntarily surrendered to the tribunal and made his first initial appearance the next day, where he pleaded not guilty to each of the 3 counts set forth in the initial indictment. After failed attempts to transfer the case to a national jurisdiction and failed attempts to proceed with the case before the tribunal on the basis of a guilty plea agreement between Bagaragaza and the prosecution, the parties filed another guilty plea agreement in August of this year. This time, the trial chamber accepted the agreement after being satisfied that Bagaragaza's acceptance of the plea agreement was made freely and voluntarily, and that it was informed and unequivocal. With leave from the chamber, the prosecutor filed an amended indictment charging Bagaragaza with 1 count of complicity in genocide, to which Bagaragaza pleaded guilty. On 3rd November 2009, the chamber heard 1 character witness. On the following day, the chamber admitted 12 written character statements into evidence, as well as the parties' joint statement on agreed facts concerning Bagaragaza's cooperation with the prosecution. On that day, the chamber also heard the parties' submissions on sentencing and Michel Bagaragaza's personal address expressing remorse for his actions. Michel Bagaragaza was born in 1945 in Bushiro region, Gisenyi Commune, Gisenyi Prefecture in Rwanda. He is married and the father of 8 children. Before the genocide, Bagaragaza had become the Director General of OCT, the government office that controlled the tea industry in Rwanda. In this capacity, he controlled 11 tea factories, which employed approximately 55,000 persons. He was also the vice president of Banque Continentale Africaine au Rwanda and a member of the Comité Préfectoral of the MRND political party in Gisenyi Prefecture. He also confessed to being part of a powerful and tightly knit group of people known as the Akasu that exercised substantial political and financial power in Rwanda and included the family members of the president of Rwanda. In accordance with Bagaragaza's guilty plea, the Chamber has found him guilty of complicity in genocide for having substantially contributed to the killings of more than 1,000 Tutsis who sought refuge at Kesho Hill and at Nyundo Cathedral. Thus, he aided and abetted the planners and principal perpetrators of the killings, including military and civilian leaders and members of the Interahamwe militia, members of the Presidential Guard, military personnel, and the staff of the Rubaya and Nyabitu tea factories. Bagaragaza knew that the planners and the principal perpetrators had the special genocidal intent to destroy, in whole or in part, the Tutsi ethnic group, but he did not himself share that special intent. As to the particulars of Bagaragaza's actions, the Chamber, in accordance with his confession, has found that on or about 8 April 1994, he participated in a meeting with the Burgmestre and the chief of the Interahamwe and an assistant Burgmestre of Gisenyi Commune, Thomas Kuradusenge, and learned that the two men had agreed that Kuradusenge would organize and lead attacks against Tutsis who had sought refuge at Keshe Hill and Nyundo Cathedral, and that reinforcements would continue to be sent to the attackers. Further, Bagaragaza authorized that vehicles and fuel from the Rubaya and Nyabitu tea factories be used to transport members of the Interahamwe for the attacks, that the attackers be provided with weapons which he had allowed the army to conceal at the tea factories in 1993, and that personnel from the factories participate in the attacks. Moreover, he met with Kuradusenge 2 or 3 times between 9 and 13 April 1994, and on Kuradusenge's request, gave him a substantial amount of money to buy alcohol for the Interahamwe in order to motivate them to continue with the killings in the Kabaya and Bugui areas. In determining the sentence, the Chamber has considered a number of factors that will be addressed in the written reasons for the judgment. In this summary, the Chamber will only address the most decisive factors for its sentencing decision. Bagaragaza's offense relates to genocide, which is the most heinous of crimes known to mankind. In this case, more than 1,000 Tutsi who were fleeing their attackers were killed indiscriminately only because of their ethnicity. With respect to Bagaragaza's mode and degree of participation in that crime, however, the Chamber notes that Bagaragaza is not charged with participating in the planning or the execution of the killings, or with aiding and abetting the planners and principal perpetrators while sharing their genocidal intent. His offense is aiding and abetting the genocidaires to a substantial degree with knowledge of their genocidal intent. Further, there is no basis in the agreed facts presented to the Chamber to assume that Bagaragaza consented to the military's concealment of weapons at the tea factories in 1993 so that they could be used for genocidal acts, or that he otherwise acted with premeditation when he complied with the requests of the local political and Interahamwe leaders. The defense has led credible evidence that Bagaragaza in his personal and professional life showed no bias against the Tutsi and was on excellent terms with them. Therefore, and considering the circumstances, it is likely that when agreeing to provide assistance to the genocidaires, he was motivated by concern for the safety of his family and himself. However, there is no sufficient basis in the agreed facts or the evidence of character witnesses to conclude that Bagaragaza, being a very resourceful person, would have faced imminent danger had he not complied with the requests of the local political and Interahamwe leaders. With respect to aggravating and mitigating factors, the Chamber notes that the prosecution has not made any submissions on particular aggravating factors and that it has concurred with the defense's submissions on particular mitigating factors. The Chamber acknowledges as particularly important mitigating factors that Bagaragaza surrendered voluntarily to the tribunal in August 2005, that he pleaded guilty when the charges were amended to comport with his confession, and that he thereby and in his public address to the court has shown genuine remorse for his actions. Even more important, however, is the fact that Bagaragaza has provided invaluable assistance to the prosecution in its investigations. His assistance started before he was indicted without concern for self-incrimination, continued without reservation after he was indicted and detained, and he has indicated his willingness to also assist in the future. Bagaragaza has thereby, to a remarkable degree, contributed to the process of truth-finding with respect to the Rwandan tragedy and to national reconciliation. This warrants a substantial reduction of the sentence that the gravity of his offense would otherwise carry. The parties have made a joint recommendation for a prison term of 6 to 10 years. The Chamber is not bound by the joint recommendation, but has taken it into due consideration. Mr. Bagaragaza, will you please stand up while your sentence is pronounced? The court sentences Michel Bagaragaza to a prison term of 8 years with credit for the time he has spent in detention since his arrest on 15 August 2005 and will spend in detention until he can start serving his sentence. Mr. Bagaragaza, you may sit down again. It seems to follow from the terms of the joint guilty plea agreement that there will be no appeal from either side against this judgment. If that is the case, the President of the Tribunal will, as soon as possible, in accordance with his practice direction on this issue, designate in which state Bagaragaza shall serve his sentence. At the conclusion of this case, the bench wishes to commend counsel on both sides and their teams for the exemplary way in which they have cooperated to have this case completed in an expeditious and just manner. The bench also thanks the registry, the interpreters, the court recorders, as well as the audio-video unit and the security staff for their usual excellent assistance. The case against Michel Bagaragaza is hereby adjourned.
All rise.